Hi everyone, and welcome back to our webinar today. Today we're talking about the Employment Rights Act, but with a focus on your HR systems. We have about an hour booked for this webinar, and we'll spend about 45 minutes on the presentation before moving on to questions at the end. So I am Juliet, I am the Director of HR Operations here at Impact HR, and I'll be sharing our knowledge on the Employment Rights Act today, along with Sonia Powell.
Hi, I'm Sonia. I am a HRIS consultant at Tugela People. I'm here to share my knowledge on the system changes that need considering as a result of the ERA.
Thanks, Sonia. And we are also joined by Grace Rogers today, who's HR Coordinator at Impact HR. Grace will be supporting us in collating all of the questions that are asked throughout the webinar. So as you know, we are using GoToWebinar to host this webinar with you today. So for those of you that haven't used it before, you are all muted and we can't see you, but you can ask us any questions. So type some questions into the chat, and depending on whether you're using the web version or the desktop version, you can navigate to the relevant part of the app to ask us those questions. We will try to answer as many questions as we can at the end of the webinar, time permitting, and we shall also be asking you some questions today. We have some polls set up, so when we get to that section, there'll be another pop-up on your screen for you to choose the relevant response. Before we begin, I just wanted to introduce you to us here at Impact HR. So we provide HR support that's built around your business, not a one-size-fits-all model. So whether you are an SME who's gearing up for growth or an organisation just looking to strengthen your existing processes, we are here and we can adapt to what you need in terms of your HR support. Our approach here is really flexible. We want to streamline your operations and help you stay on top of your HR practices and employment law, and really free up your time to focus on your people and focus on your business. We understand that real challenges come with managing people, particularly for SMEs, and our work is grounded really in practical expertise, hands-on support, and delivering outcomes that can really make a difference for you. And that can be from creating contracts and handbooks, or supporting through any sort of disciplinary processes, guiding you through redundancy or change consultations. We're here to help you when you need us. And we also work flexibly with you as well. We have lots of different ways that we can support, for example, on a retained basis or on a pay-as-you-go or a project basis, and we can always tailor them to fit the needs of your organisation.
So Tugela People, we're a specialist HR and payroll systems consultancy, helping organisations select, implement and optimise cloud-based HR technology. We work with ambitious businesses to ensure their people systems are not just operational, but strategically aligned, enabling better decision-making, improved employee experience and scalable growth. Our expertise spans the full HRIS lifecycle, including system selection and vendor evaluation, implementation and configuration of platforms such as Sage People, payroll integration and optimization, data quality, reporting and analytics, ongoing system improvement and transformation. As part of Impact HR Consulting, Tugela People combines deep technical expertise with practical HR knowledge, bridging the gap between people strategy and technology delivery. Our focus is simple, helping organisations get more value from their HR systems with clarity, confidence and measurable impact.
Thanks, Sonia. So before we get into the detail, we just want to briefly run through what we're going to be covering in today's session. So here at Impact HR, we've been talking about the Employment Rights Act for a while now, and that's no surprise as it represents one of the most significant sets of changes to UK employment law in recent years. And for employers, these changes will have practical implications for how people are recruited, how they are managed and supported generally day to day within the workplace. So for leaders and HR teams, understanding what's coming and preparing early for each stage of the implementation is going to be key to avoiding risk and ensuring that you all remain compliant within your businesses. So today's session is designed to give you a clear overview of where things currently stand and what you should be thinking about as an employer. with that particular focus on the impact on your HR systems, just to ensure that they are ready and geared up for the upcoming changes through the new legislation. We will talk through what's actually changing. Some of these changes will affect core HR processes, such as your contracts, policies, and probation periods, which we're going to talk through, and how certain workplace issues are handled. And Sonia will be speaking about how these changes then may affect your systems and how to get these ready. We will also look at the implementation timetable because these changes won't all happen at once. So understanding the likely timeline will help you prioritise what needs your attention now compared to what can be planned in for later. We will look at what these reforms mean in practice for employers in terms of your processes and your systems and the potential implications for businesses and leadership teams and HR functions. And then we'll finish with some practical actions that you can start thinking about now so that you're better prepared for when the legislation actually takes effect. So the aim of today's session isn't just to explain the legislation, but to also help you leave with a clearer understanding of what it could mean for your organisation and your systems, and the steps that you may want to start considering. So I did mention that we have a few questions for you. So before we begin, we wanted to ask you a question through our poll to find out a little bit about who is here with us today on the webinar. So as we have that focus on HR systems, we have our first question to ask: what type of HR system do you currently use? So you can see the options up on the screen. I think there'll be a poll coming up for you now. So it would be really handy if you could put your answers into our poll just here, and then we can see what systems are in use, and it will give us an idea of how to tailor what we talk about with you today. So I can see some results coming through now. Thank you. I'll give it a minute. Right, I think that's all of our results then coming through. That's great, thank you. Can you see the results, Sonia?
I can't, no. Grace, can you see them?
Yeah, so I think we've got half are coming through for basic HR software. And we've got about a quarter coming through for the core HRIS, and then another quarter for the HCM platform. We don't have anybody who's voted at the moment for the advanced or the enterprise. So just to give you an idea of who's with us today. Thank you. And before we move on, we have another question for you. So this is a question: how many UK-based employees do you have in your organisation? So again, we would just like to get a little bit of information just to give us a steer on the topics that we focus on with you throughout this webinar. So I can see the poll up on the screen now. Do you want to add your results? Okay, so the results on this one have come through. We've got appeared. I think the majority were in the smaller bracket, and then there was about a quarter in the next bracket up, and then a smaller percentage in the next one up from there. But we didn't have anybody in the top bracket, so that just gives an idea then as to who is with us today. Thank you everybody for putting in your answers on our polls. Okay, so moving on to the content. We are looking at the status and the timeline. So before we look at the individual changes, it's helpful just to understand where we are in the process and how the implementation will unfold. So everything we talk about today is as it stands at the end of March 2026. So we first covered this topic when it was the Employment Rights Bill last year. So the first key point is that the bill has now passed the parliamentary process and it received royal assent in December last year. So this means that it has officially become the Employment Rights Act 2025. However, royal assent doesn't mean that every change then happens immediately. Instead, the government introduces the reforms in stages over a number of years, and this phased approach is designed to give employers time to prepare, review their processes, and make any necessary adjustments, which is also really helpful that we don't have everything that comes in just all at once. So the implementation began in February 2026, a couple of months ago, when the first set of measures came into force. Further changes are scheduled to follow in April, so next week, and then October 2026, meaning that throughout this year, we'll start to see the first practical impacts of the legislation. And then the rollout continues into 2027 with additional measures expected in January. And beyond that, further phases anticipated for April and October, which is when the law tends to change throughout the year. But the 2027 dates are expected timelines, which means that they might be refined. And we are waiting for a few more details. There may be regulations and guidance that's published around those changes that come next year. So what this means in practice is that while the Act is now law, the real impact for employers will emerge gradually over the next couple of years. So for businesses, this phased implementation is actually helpful. It provides time to understand the changes, review our policies and procedures, and make sure that the organisation is prepared before each stage comes into force. So throughout the rest of this session, we'll highlight which changes are likely to appear in which phase, and you can start to think about what actions then you might need to take and when. We have another question for you. So this one is, how prepared do you feel your organisation is for the changes throughout the Employment Rights Act? And it's just to gauge how much people have been looking into this already, if you've made any updates so far, or if you don't feel very prepared at all. So there'll be another poll coming up for you.
Hi, Julia. I can't see that poll listed, unfortunately, and I can't set it up as we're going through it either.
Oh,
So,
no, that's fine.
Yeah,
Not
unfortunately, I can't enable that one.
That's okay. Thank you, Grace. Well, the question was just to, again, gauge where people felt they were in terms of this process. As I mentioned, some things already happened in February, more things are coming next month, and it was just to understand then how people felt about those changes, because as I said, they are quite significant. So we'll move on from this poll then. That's fine. So looking at the key changes. We will talk through a lot of these in a lot more detail, but just as a headline, the key changes include unfair dismissal from 6 months of service, family-friendly reforms, statutory sick pay changes, simplification of trade union processes, zero-hour contracts and guaranteed work, restrictions to fire and rehire practices, changes to flexible working requests, tribunal reforms and reporting requirements, and stronger rules around sexual harassment in the workplace. There are lots of other topics within the Employment Rights Act, and we just don't have time to cover everything today, but we will cover off a lot throughout the session, but also a few more briefly at the end of the webinar. So the first topic today is unfair dismissal. So what's changing here? Employees will be protected from 6 months of employment rather than having to have the 2-year qualifying period that is in place currently. Also changing is the compensatory award cap. This will be removed entirely. Currently, the cap is set at just over 118,000 due to increase in April, which means that higher earners would face a cap on what they could win through an unfair dismissal claim. These are all confirmed to change from the 1st of January 2027. However, this will apply to those employees who start employment from the 1st of July this year, as by the time that they get to the 1st of January, they will have their 6 months of service. So as we look at what actions to take, these will need to be implemented within your organisation now to start thinking about them to begin managing this new way of working as part of your processes. So what does this mean for employers then? Well, greater risk from termination decisions. So currently employers have a 2-year period to make a decision about whether somebody is suitable for the role if they are working out. And in most cases that has relatively lower risk. However, this will no longer be the case, as every termination decision nearing that 6-month service mark and beyond will carry risk for an employer to consider. It is estimated that this will extend the unfair dismissal protection to around 6 million more employees who would not have qualified previously. And then with regards to the compensatory cap, when that is removed, we expect to see more claims being raised at a higher value. So currently with the cap in place, it means that higher earners have tended to settle their claims outside of the tribunal system. But going forward, we might see that higher earners may be less inclined to negotiate through a settlement process, for example, if they know that they have a strong claim once the compensatory cap is removed. What this means for employers, another big one, is that probationary periods will become a lot more important. So with the service requirement then for unfair dismissal being set at 6 months, this means that the probation period is going to be something the employer can set and manage according to their own processes, but it must be reviewed to ensure it is fit for purpose. For example, if probation periods up to now have been 6 months in duration, we are urging employers to review this, as when that employee reaches 6 months of service and therefore gains the right to claim unfair dismissal, it's already going to be too late to rely on this as a reason to fail a probation period. So instead, what we're suggesting is that probation periods will need to be shorter in duration and closely managed to allow line managers to the opportunity to review the suitability for new starters accordingly in that shorter time frame. And linked to this then, the performance management process during that probation period will become critical, and the documentation of that process too. So if a manager is making a termination decision, employers will need to have a strong reason to dismiss based on sufficient evidence to back up their decision. So some actions to take now then would be to review your current recruitment, selection and onboarding processes, just to ensure that you've got a robust process in place already to ideally make the right decision for the hiring process in the first place, with a view to reducing any need to terminate any new hires in that time frame. We're also advising to audit your existing probation period process, like reviewing what you've got in place currently. Does it work? Have you got a probation period in place currently? If not, do you need to implement one? Or even if you do have one, are your managers following it to actually review performance during that time? So it would be a case of updating and creating any documentation that refers to probation periods and ensuring that they are followed throughout. As part of that, it could be developing a framework around performance review to provide a structure around that process so that it's simple to use really for your managers to support and develop your people ideally, but also then to provide that evidence should you need to make any decisions around termination. And then linked to that then is training your managers on handling performance from day one throughout the probation period. So this is going to be key. So it won't matter if you have the best process and the best framework in place if your managers are not trained in it and if they don't then use it. So train your managers on the process for managing performance, but also on the process for making those termination dismissals, just to ensure that they are handled correctly and again that they're following the process to reduce any risk in that time. Of course, we are here at Impact HR to provide advice on this kind of process, so please do reach out to us. That's what we do day to day, so we can take away any stress that might cause within your organisation and ensure that you can remain compliant. And then overall, I've put on this slide to foster a positive workplace culture. So a lot of claims from employees really come from them feeling disgruntled about the way that they've been treated. So by having that positive workplace culture in the first place, can really reduce that by showing that you are treating them fairly and respectfully, even when ending employment.
So, as mentioned by Juliet, when reviewing recruitment, selection and onboarding processes, it's also important to understand what information is held in your HR system that may also need to be reviewed. So, for example, what probationary periods are being held? Do these need to be updated, and do any need to be removed? How can you use system functionality to support a more effective probationary review process, such as utilising the performance module to create a probationary review form and objective setting, using email alerts throughout the review process to remind both the employee and manager to review the progress, or have regular check-in reviews, again with automated email reminders. Review and update system reports and any dashboards to enable you to monitor employees throughout their probationary period, to enable HR to identify any issues, non-compliance, and prompts to line managers. Onboarding surveys triggered to employees within their probationary period can be a really good way to gauge their onboarding experience and help identify any concerns early on, which also supports fostering the positive workplace culture mentioned earlier by Juliet. Finally, availability of documents such as job descriptions and contracts for the employee on the self-service portal, as well as policies and prompts of any updates of these, which will enable employees to have easy access should they wish to review and keep themselves informed.
Thanks, Sonia. Yeah, I think that's really interesting what you mentioned there about having the system remind your managers to follow this process, because like I was saying, if you have the framework in place but managers don't follow it, then it's going to fall down. So that's really where your system then can really help that process, isn't it, in terms of making sure your managers are on track.
Absolutely.
So moving on to the next topic that we're going to cover is statutory sick pay. So what's changing here is that statutory sick pay will be payable from day one of the sickness absence, which is removing the 3 waiting days that are in place currently. Also, the lower earnings limit eligibility criteria is going to be removed, and the weekly rate of SSP is increasing to just over £123 per week. So all of these things are confirmed to change from the 6th of April 2026, which is only a few days away. So what this means for you as employers then is increased costs, unfortunately, to cover more days of absence with SSP. Potentially more short-term intermittent absences of your employees taking like the odd days off when they now benefit or will now benefit from SSP during those first 3 days, when before they would have been unpaid. So a few actions to take now to prepare would be to just ensure that your payroll provider is briefed on these changes, and also brief your line managers. As we were saying, your line managers are at the forefront of this, dealing with their employees day to day. So just to ensure that your line managers have the training and the tools to manage absences in their team. So this might include also reviewing your documentation in relation to things like return to work forms, self-certificates, but also reminding managers of their role in keeping in contact with employees when they're off sick, or if they're reviewing their absence trigger points, and ensuring their own employees follow the correct absence reporting procedures. And all of these tools can help to manage those short-term intermittent absences that we might now see an increase in. And then review your current HR documentation in terms of policies, your contracts, and as we mentioned, your absence management forms as well, to ensure around SSP and the eligibility criteria.
So what does this mean in respect to your HR systems and your employee self-service portal? So some actions that you might want to consider are, first of all, ensuring your HR and payroll systems are updated to reflect the SSP Day 1 entitlements. Upload any new policies on the self-service, highlighting the changes for all employees, maybe by adding a notice board or an alert of the change for them to see. If absence is managed by employees or managers in the HR system, ensure that all absences are recorded accurately. Ensure any changes to policy are also updated in the HR system, such as system rules for payments or payroll notifications. Can utilise automated reminders for return to work meetings, highlighting any short-term absence trigger reviews. And if not already in place, maybe create an online self-certification form, which can be automatically triggered if an employee inputs a sickness absence. And also review, update, or create sickness absence reports or dashboards, both for HR teams and line managers, that can measure the number of absences, any trends, any reasons that continue, and also trigger points.
Great, thank you. I think with this one, there are lots of updates that can be made in the system, can't there? And I think it's a good point that you make about any updates that are made to policies or forms to also then update that in the system just to ensure consistency, so that if employees or managers pick up a form, or if it's an online form, that they are all consistent across the board.
Yeah, absolutely.
Thank you. Our next topic is family-friendly reforms. So what's changing here? Paternity leave is becoming a day one right, and this is removing the current requirement to have 26 weeks of service. Also, unpaid parental leave is becoming a day one right too, and that's removing the current requirement to have 1 year of service. And outside of the Employment Rights Act, but it's coming in at the same time in April, is the bereaved parents paternity leave, which allows a parent to take up to 52 weeks of leave to care for a child if the primary carer of the child unfortunately dies. So this is a new type of leave that is being introduced. As I mentioned then, these are all confirmed to be coming in from April 2026. There are other proposals around family friendly too. So the government is also reviewing carers leave. Now this already came into force in April 2024, but they are considering introducing it as paid leave, as currently it is unpaid, but this is all to be confirmed. Along with bereavement leave. So this is proposed to be a day one right, allowing employees to take at least 1 week of bereavement leave. And it's unknown at this point if it's going to be paid or not, again, to be confirmed. There's also going to be an increased entitlement of parental bereavement leave to provide for 2 weeks of statutory bereavement leave for parents who unfortunately experience pregnancy loss before 24 weeks, as this is currently not covered. And there are going to be additional protections against dismissal for a woman when she is pregnant, on maternity, or within 6 months of returning, with some exceptions. This is likely to also cover those on adoption leave and shared parental leave. It's not yet clear what the exceptions are going to be, but it might include cases of genuine redundancies, for example, like a closure of a business. But the whole principle behind this proposal in the Employment Rights Act is to enhance job security for new and expectant mothers. And those changes there are expected to be from 2027. We just haven't got the exact implementation date as yet. So what does this mean for you as employers then? So more employees will be able to take time away from work, as there will be more people who will be entitled to the different options for leave from day one of employment. So across that paternity, parental, and then bereavement later on, etc. There's going to be then a potential increase in short-term or unplanned leave due to more people being eligible for paternity leave, parental leave, carers leave, bereavement. So that can create an additional absences, especially when they are just short notice, and also especially for smaller organisations. So that would highlight the need for sufficient workforce planning and like cross-training to ensure there is adequate cover of work. This also, though, can be seen as an opportunity for you as an organisation to review your culture and embrace a family-friendly way of working and use it as a way to really attract and retain talent. Can be one of the benefits that you put out there as a come and work at our organisation. So some actions to take now would be to review your family-friendly policies to ensure that they reflect the new legislation. For example, removing the requirement for the length of service to become eligible. Also, review your processes around any restructures or redundancies just to ensure that they then include the safeguard to identify any new or expectant mothers, just so that you don't fall foul of that update in the legislation coming through next year. And then also train your line managers in the updated processes, in how to handle new leave requests, ensure that they understand the enhanced protections around expectant mothers as well, and ensure that they properly handle the leave process with their team managers, including the return to work process as well, not forgetting that. And then finally, some action to take is to communicate the updates to your staff so that they're aware of their rights in relation to family leave options, but also how they request it and what timeframes for notification that they need to work within.
Okay, Juliet. So from a system perspective, to support these actions and changes in policy, there's some suggestions for you here. So ensure that the absence reasons for family-related absences in your HR system are there and they're available for use, especially the new ones. And will anything additional need to be fed through to the payroll system, such as when the leave types are changing from unpaid to paid, such as carers leave. Add the updated policies to your employee self-service portal, again using prompts to either encourage or confirm the updates have been read and understood by your employees. Remove any service limitations that would have previously prevented an employee booking one of these family-related absences, such as your paternity leave. Do any additional fields need to be created in the system or used in order to capture any additional information or to be used for reporting purposes? What automations do you currently have set in the system that either trigger alerts or update another area of the system? And do these need to be updated or changed? Ensure all online leave request forms or letter templates are in line with the new legislation and are fit for purpose. Do you currently have paper forms that could actually be converted to online forms that therefore creates a more robust mechanism for recording and managing your family-friendly absences?
Thank you, Sonia. Lots of things to think about there for systems, isn't there? I am a real big advocate for having a form online rather than paper. Paper gets lost very easily. So yeah, lots to think about there for family friendly in your systems. Our next topic is 0-hour contracts. So what's changing here is that 0 hours workers will be entitled to request a guaranteed hours contract to reflect any regular working hours. This is going to be based on a reference period, which is still to be confirmed, but we think likely to be a 12-week reference period. 0 hours workers will be entitled to notice and pay for short notice shift changes as well. So there are still some unknowns with this, and say what we don't know at the moment is the reference period, like how long that's going to be, and how the regular hours will be determined in practice, and also what the reasonable notice of a shift change might look like. However, again, we think that's probably going to be like 7 days notice. So this is expected in 2027, so it's a bit further on down the line, but actually is something to look at now, because for especially for those organisations that rely on 0 hours workers, for example, if you are in the care sector or hospitality, for example, it's certainly something to look at now so that you can be prepared. It is important to note that this part of the Act doesn't ban 0 hours completely. Tries to tackle those situations where they are perhaps leaving workers with a lack of job security or financial security, and putting in place the guaranteed hours contract where working regular hours. So what does this mean for employers? It may mean that there will be more employees on guaranteed hours contracts. So as I mentioned, for those sectors that rely on 0 hours contracts, this could reduce that flexibility that you've had in the past. There's going to be a need for more proactive planning of shifts and rotas. That's going to be critical, as employees will need that minimum notice of any shift changes, and would be able to refuse last minute shift changes if they were not given the required notice. Workers would also be able to claim compensation from their employer for any last-minute shift changes, which is another area for potential additional cost to an organisation. And with all of this, it seems like there's going to be that increased admin burden of setting the rota, ensuring staff availability, ensuring cover, and cover with the right skills in the right areas, tracking hours, and also managing any claims for compensation for any last minute shift changes too. So some actions to take now, as I mentioned then, review who's currently on a 0 hours contract within your organisation and look at their working pattern. Is anybody working what may appear to be regular hours and over what time frame? Consider whether that's the right kind of contract for them. Is it still suitable for their working arrangements, as they may have been brought on in a 0 hours arrangement, but things might have changed over time, and actually without noticing it, they may be then just working set hours week in, week out. And review your current shift patterns. Do they cover what you need currently? Are they set up in good time? Are you changing shifts at the last minute? So if so, what could be done to put in place to avoid that, and make them a little bit more arranged then for the organisation, but also for your staff.
Okay, thanks, Juliet. So when we're thinking now about the system actions that you need to think about, some of the ones that have come to mind for myself are reviewing what mechanisms you currently have in place to track and monitor hours that are being worked. If the reference period being talked about is set at 12 weeks, how would you track this and identify any workers who may be able to request guaranteed hours? Consider at this point whether you need to implement a new system or upgrade your current system to cope with the increased requirements, such as utilising timesheet functionality or a TNA system integration. Add, as I've said on each of the slides, any updated policies to your employee self-service portal, along with considering the ability for employees to request a contract based on their average hours over the reference period. How will employees have visibility of their average hours? Can fields be added to your current HR system that calculate this, which could then be available on their self-service? And finally, ensure the information collected in your HR system is robust in order to feed through to your payroll system to provide both accurate pay information as well as for the accurate calculation of holiday pay.
Lovely, thank you, Sonia. You mentioned TNA system there. Just for any of our listeners, if they're not sure what that means, what's the acronym?
It's time and attendance.
Oh, lovely, thank you.
System.
And yes, again, lots of updates to make to the system in this area, isn't there? I think it's all about the data that you have and the visibility of that data as well, of knowing who's working where, when, and what changes need to be made. So yeah, it might be a case of implementing a new system if you don't currently have that already, just to make this section a whole lot easier. So the next topic we're looking at is flexible working. So what's changing here is flexible working then is due to become the default option, where employers would be expected to look at how a flexible working request could work in the first instance. So there's going to be more responsibility on employers to approve requests unless they have a valid business reason for refusal. This is expected, again, another one for 2027, and we know that there were consultations on this topic, and we are expecting an updated code of practice to be published for employers to refer to as a guide in how to manage this process. But what we do know, and what this means for employers, is that there's probably going to be an increased request for thinking or just varied working patterns, and potentially create more complications for those managing workforce planning for shifts and rotas and cover, as we've just spoken about. It may also be seen as an opportunity for employers to attract and retain talent by promoting that flexibility within your workplace. Similar to what we talked about with the family-friendly reforms, it could be an opportunity to say, look, this is a benefit of working at our organisation. It is going to be dependent on the type of sector that your organisation's in and the type of role itself. But as we've seen over recent years, that working practices have developed and changed so much that there is more of an expectation for some kind of flexibility or hybrid working at the moment or going forward. So what to do now, actions to take. We are advising to review your current policies on flexible working and assess whether they are the most up to date, because there were some changes to this legislation back in 2024 and that removed the service eligibility to be a day one right. It increased the number of requests that employees can make from 1 to 2 per year, and it also reduced the time frame for employers to process a request from start to finish from 3 months to 2 months. And just ensuring then that your policies are adaptable to the new way of working when this comes into force as of next year. Be mindful that discussions around flexible working might begin during the recruitment stage now that it is that day one right. So you might have to just review your recruitment policies too, in case it is mentioned in there. Another action then is to assess your capacity to manage flexible working requests against your workload, and given that there may be that influx of increased requests. Therefore, implement clear processes and decision-making frameworks for handling flexible working requests and ensure that you've got a clear documentation and clear process set out for your managers to follow should they receive a request from a team member. So that review can involve looking at what kinds of flexible working arrangements may work within your organisation or may not work if that's the case, and therefore preparing your business reasons to have a response that may then be applicable across the board or for a particular role or for a particular team. So whilst you can get these ready and have them ready there if you have any requests coming in, don't forget to review each case on a case-by-case basis and also reach out to us for advice on this. Again, this is something we can support you with. And finally, along with everything that we've said, is to train your line managers on your policy around flexible working, on your procedure, and also the process for them to follow in terms of the process that your organisation has set out in line with the legislation. So in terms of the time frame, the duration and the documentation, but also to have a strong and robust evidence-based reason to decline a request should that be the outcome of the process. So it's really about looking to change the mindset around the approach to flexible working requests, rather than it being that immediate answer of no, we don't want this, to how can we make this work? So make use of the tools at your disposal in this process, such as trial periods. You can implement a trial period, for example, 3 months to see how it goes and demonstrate that you are willing to give it a go. Or other options to meet the employee partway with their request if you can't meet it fully.
So what do we do in relation to system actions? So to ensure that the areas Juliet's talked about are reflected. So some of the ideas that have come across are, could you or do you use online forms or have online templates to enable employees to request flexible working? Are these forms up to date with the latest legal changes, as well as considering any updates for the future changes? Do the guidance notes within these forms correctly detail the current legislation? How could you or how do you track flexible working requests within your HR system to ensure they're being managed and progressed within the 2-month timescale set out by the current legislation? And of course, add the updated policies onto the self-service to give employees easy access to them. In order to ensure managers are making evidence-based reasons for any refusals, consider whether an online form could be utilised detailing the 8 reasons for the manager to select, along with the rationale for this. This could then be submitted via the system to both retain this information on the employee's records, as well as being used for outcome letters and reporting. You could even create an additional area in the system to retain this information. Additional fields might be required to ensure this information is accurately captured and retained. And of course, if all of this information is being created, utilised and updated in the HR system, you may also want to think about whether you put an approval process in place just to increase the robustness of any refusals.
Great, thank you, Sonia. And our final topic that we're going to cover in detail today is the Fair Work Agency and enforcement reforms. So what is changing here then? The Fair Work Agency will have powers to bring tribunal proceedings on behalf of workers. And this means that there will be a more stringent obligation on employers for record keeping in order to defend any such claims that might come through. So whilst the Fair Work Agency is new and it brings with it new powers for enforcement, it actually brings together existing enforcement agencies for things like the minimum wage, the Gang Masters and Labour Abuse Authority and others. So the Fair Work Agency will also have new powers to enter workplaces and ask to see documentation and records to inspect them to ensure that employers are following the rules. So this is new for the UK, so we will see how this pans out as and when it comes in on the 7th of April 2026. So what does this mean? An increased likelihood of tribunal cases or financial penalties from the Fair Work Agency if they come across non-compliance. So therefore increased costs for organisations if they fall foul of the new laws. There will be an increased requirement for record keeping on things like holiday pay, leave, sick pay, shifts, etc. As this requirement is to keep the data for up to 6 years, which is a significant admin burden, really. And I know Sonia will talk about that in a moment in terms of the system and record keeping. There's going to be enhanced scrutiny by the Fair Work Agency, so prepare for transparency as the Fair Work Agency will be reporting on and publishing their work, which means any non-compliance could also become more visible. So some actions to take would be to review your current processes and ensure that they are compliant to mitigate potential disputes. So how can your current processes be enhanced to foster that positive working environment that we mentioned earlier, just to reduce the number of disputes, reduce the number of issues that might come through from employees or from the Fair Work Agency for this non-compliance, but also know how to deal with them robustly and resolve any disputes before they can potentially escalate. And then we're also advising to inform your line managers about the new enforcement rights, as falling foul of these could result in tribunal claims or fines, and bring potential impact on reputation to the organisation as well.
So this is where, in my view, your HR system can really come into its own when thinking about how you can evidence the data if requested by the Fair Work Agency. Our recommendations would be to review how your pay, holiday and sick pay data is recorded and stored currently. As Juliet said, the Fair Work Agency will be able to ask for this data at any time. So we're advising that this is reviewed now so you can get your data in order in case this is requested at any point. If you notice any discrepancies in the data, such as any underpayments, you now have that chance to correct them, rather than waiting for a claim to come through from an employee or the Fair Work Agency themselves. Ensure your systems are set up to store and retrieve relevant data that may be needed at future points in time. Identify what records you keep, how long you keep them, and whether they meet the new expected standards. Consider what functionality you can enhance or upgrade to ensure that they support with long-term data storage, reporting, and easy data retrieval. Think about what reports and dashboards can be updated or built in order to capture the required information, both going forwards as well as looking back, to review for any potential discrepancies. If this information was requested, can you supply all the data quickly and accurately? Thinking about system automations, do you currently have or could you have anything that proactively flags changes, such as national minimum and living wage rate changes, as well as any service-related changes? For part-time workers, review the FTE calculations to ensure that these employees are accruing holiday at the correct rate. And finally, review how and what is feeding through to your third-party providers, especially payroll, to ensure accurate and legal payments. Julia.
Great, thanks, Sonia. I think, yeah, you mentioned this is where systems are really going to come into their own, isn't it? With this reporting and the requirements to quickly pull data and then, well, have the data there in the first place, but also then retrieve it and know that it's accurate as well. So, yeah, quite a big area for the world of systems and the system within your organisation as well. So, thank you.
Yeah. Especially also as the period 6 years that all the data has to be kept for. So yeah, having it in a system rather than on paper will make it much easier.
On paper, exactly. Yes, I was just thinking the same. You wouldn't want to be going through a filing cabinet, going back through all of that data. So yeah, pulling it off the system is the easy answer. We have another question for you on the webinar today, and it's around the Fair Work Agency. So if the Fair Work Agency came to you and requested this kind of information, how prepared would you feel? And is this a poll that we have, Grace, set up to share? Brilliant.
Yes,
So
hopefully you can all see this one on there.
Yes. Thank you. I think this is going to be a really interesting one because it's new. And whilst we've had other enforcement bodies around, we've not really had it in this kind of way where they can literally turn up at your organisation and request this information and expect you to provide it there and then. So it's going to be interesting to see how people feel about this one.
I think it's also flown relatively below the radar as well. I don't think there has been that much shouted out about it.
Yeah, absolutely. It's not really been one of the headline grabbing topics within the Employment Rights Act. It's all been about the unfair dismissal. That's the one that everybody seems to know about. So yeah, this one has kind of gone under the radar, like you say, and things that have come out in terms of how they're going to work, I think, yeah, have been missed by a few people. So I think it's really important that we cover it off today with you. Great, so I can see the results have come through. It's a bit of a split between quite prepared, which is brilliant, and not very prepared. So I think that's actually quite a good indication of organisations and how they're feeling at the moment. So every organisation is going to be at a different stage in terms of this, in terms of how prepared they are, and it will probably vary depending on what resources that you have already, what systems you have in place too. Like if you're working on a system, if you've got it all there, that you feel quite happy with it. Or like Sonia said, if you're working from paper still, probably going to be in that not very prepared bracket. So hopefully then with some of the things that we've covered today will help you then to become a little bit more prepared for that. And here we also have a few more resources on the Fair Work Agency that we will be sharing with you. So I mentioned that there are lots of changes coming through with the Employment Rights Act, and we just simply don't have time to cover everything. But as a bit of a summary, the other changes also include trade union reform. So this is simplifying the trade union recognition process and essentially making it easier for employees to access trade unions within their organisation. There are collective consultation changes for redundancy. So this is increasing the protective award available to collective redundancy processes and also reviewing the threshold of 20 or more redundancies proposed at one establishment, which is still to be determined. There are restrictions on fire and rehire or dismissal and re-engagement practices. And also gender pay gap and menopause action plans. So this is something that's requiring employers with 250 or more employees, I think there was a few people on the webinar in that bracket, to publish action plans on gender pay gaps and menopause. So this will be voluntary to begin with before becoming mandatory later on. Some changes to sexual harassment, which will be requiring employers to take all reasonable steps to prevent sexual harassment. And this is an enhancement on the legislation that came in before, as that currently says there's going to be that increase then to say all reasonable steps. Plus an enhancement harassment around third-party harassment as well. And then ethnicity and disability pay gap reporting. So this will be for those employers with 250 or more employees, and an extension of equal pay rights to ethnic minority workers and disabled workers. So it's a bit of a roundup of the other things that we haven't covered in much detail today. But as a wrap up of today's session, I wanted to bring everything together really into a clear set of next steps then for all the main points that we've talked through today. So looking at the key action points, there are several practical steps that you can begin taking now to prepare for the changes introduced through the Employment Rights Act. So firstly, to review your recruitment and selection and those probation processes, as we talked about earlier. So these should be structured, consistent, and clearly documented from the outset, and having that simple framework in place, ensuring managers are trained to manage any performance conversations will be increasingly important. And then, as Sonia mentioned, ensuring that the systems are updated to reflect all of those changes and your internal processes around probation reviews, setting those reminders for your managers, etc. Revisit your approach to flexible working. So with the shift towards flexible working becoming more of that default position, policies should be updated and organisations should develop, again, that clear decision-making framework so that managers can understand how to assess requests fairly and consistently. And again, using that system to manage that process so it doesn't get lost within that 2-month time frame. Review and update your family-friendly policies to reflect the new entitlements, essentially removing that service eligibility and also implementing the new types of leave, whether they are paid or unpaid. So this includes ensuring your HR systems can accurately record and manage leave, as Sonia talked through, and also that your managers understand the new rights and processes so that they can support their employees appropriately. Strengthen your employee relations processes in general, so ensure that any consultation with employees is meaningful and ensuring that managers have the tools to seek agreement where possible, and any dispute resolution procedures are clear and well understood. And it's important to recognise that the new legislation will also introduce that additional enforcement through the Fair Work Agency that we touched on at the end. So this means that organisations should review their compliance processes very carefully, how they handle disputes, but then also around their systems and their documentation and record keeping, just to ensure that they can retrieve that data if requested and also withstand any scrutiny if required. So hopefully some of these key action points can provide a bit of a practical roadmap for you to start your preparations or to continue your preparations for those of you that felt you are on your way, just to stay ahead of the changes and reduce any potential risk, and also just to become more resilient and overall compliant in the workplace as the legislation comes in throughout this year and into next year. So after this webinar, you will get a link to the webinar recording. So if you want to listen back to any particular sections that we've talked through today, you can do so. And you'll also get our contact details. So should you wish to get in touch with us to discuss any ways in which we can support you, either through Impact HR or Tugela People, please do get in touch with us about any questions about the Employment Rights Act or any HR queries, systems queries. We are here to help. I know we are short on time, but we did say we would answer any questions that you would have for us. So Grace, have we had any questions posed through the chat?
We've had a couple coming through, so I've filtered through some of them, but one of them is for you, Juliet, just asking, can we still dismiss an employee if they are not working out before the 6 months?
Yes, potentially. So the current rules around unfair dismissal are obviously up to 2 years, and we have a process to follow if we want to dismiss somebody in that 2-year period, which is essentially shorter than if they had more than 2 years. So that's going to be the same. It's going to be the same process to follow. All it means is we'll have a shorter time frame to actually action it within. So it will be within that 6-month period. So yes, that option will still be there, certainly. And there are also some caveats around day one rights, which we haven't talked about today. But I suppose if anybody is looking at that potential, it would be to get in touch with us, absolutely, and we can advise and ensure that the process is followed and that you remain compliant. But I suppose short answer is yes, it's still an option, just a much shorter time frame to do it in.
Great, thank you. And one that's come through for you, Sonia. So somebody's asked and said, in our system, employees who do not have 26-week service are unable to book paternity leave at the moment. Will we need to get this actioned and changed?
Absolutely. Yes, is the easy answer. So any service-related limitations where the law is changing, they'll need to be removed from the HR system because, for example, the parental leave, anybody should be able to book that from their day one of employment, not just after a service time frame.
Great, thank you. One more just on the HR information side as well. So what information would you look to capture in reports to enable HR teams and managers to monitor sickness levels?
So that's a really good question. Thanks, Grace. So first of all, you need to think about actually what information do you want to capture, because you can only report on what you capture. But really, you want to be looking at the number of days sickness somebody has had in a rolling 12-month period, what the reasons are for the sickness absence. So you can look at things like the number of days for each sickness period, but also like the number of days of any certain days. So there's, common issues that arise are people taking regular Mondays off or taking time off straight after a holiday. So it's being able to think about what do you want to capture that's going to give you that information and to be able to see those trends.
Lovely, thank you. I'm conscious of time, so I'll that's all the questions for now.
Lovely, thank you. I was just going to add to that answer that you gave, Sonia, that when you said it depends on what data you want to actually have and use, all comes down to the line managers as well, doesn't it, in terms of how they manage the absence in their team, what conversations they're having with their staff, how much they're keeping in contact with somebody who is off sick. So it all sort of rolls into one as to the HR process and then the system support in the background as well.
Yeah, no, absolutely. And that's where things like prompts and alerts can be really helpful, because we accept that line managers have a whole heap of other things to do. So anything that we can help to remind them through the system is, it's got to be a benefit, right?
Absolutely, yeah. So just before we finish, so I'm conscious of time, but for those of you who have stayed until the end, thank you. But we are very mindful that all these changes to the legislation is quite a lot of work for employers to implement within your organisation, and that's where we are here to help. We've even put together an Employment Rights Act voucher that we are offering to those attendees on the webinar today, which provides £250 off any HR service within Impact HR. So it's for things like anything in relation to the Employment Rights Act. So it could be a review of your handbook, your policies, your contracts to ensure that they reflect the new legislation, or some training for your line managers to raise awareness. As we've talked through everything today, it's to train your line managers and make sure that they are aware of everything that's going on. So if you would like to use your voucher, please do get in touch with us. And then we just wanted to highlight we have some really useful information on our website. So our website here at Impact HR is impacthr.co.uk. And some of these tools on our website are for free. So do go on and have a look. We have the Employment Rights Act checklist, which we can send a link to for anybody that would like to see that. You can download it. But we also have things like our HR benchmarking assessment, which is essentially like an audit of your HR function, just to understand what you've got currently, and if there are any areas that need some enhancement, just to ensure compliance in those areas. And then things like sexual harassment risk assessment is free to download on there as well. But also within our Impact Hub, you will find our webinar archive. So all of our recordings of previous topics and a lot on the Employment Rights Act, but also all of our latest news and updates too.
And likewise, Julie, at our website, tugelapeople.com. So, the sorts of services that we offer as a business. So HR system implementation. So literally supporting HR teams implement a system from scratch. Also support with HR system selection, if you're not entirely sure which system it is that you're looking to implement. Our managed services team, which help support the lifespan of your HR system once it is implemented. And then also, like Impact HR, there's also a knowledge hub on the website too.
Brilliant, thank you. And then one final question for you is, if you would like to arrange a free call with us, we can arrange like a half an hour free call with one of the team to discuss any kind of HR support or HR system support. So we have people available within Impact HR or Tugela People, or both of us if it spans across both topics. Please do pop in your vote now on the poll that we're sharing, and we can get that arranged. Lovely, thank you. And finally, a reminder of our contact details. If anybody has any questions, please do reach out to us. And thank you. Thank you for staying an extra 6 minutes. We really appreciate it. Thank you for listening and have a nice day.
Thank you very much.